What is an arraignment? An arraignment hearing is when the judge will have your criminal complaint and will review the criminal complaint with you. So let's just pretend that this piece of paper right here is your criminal complaint. The judge will go through your criminal complaint, will ask if your name is spelled correctly on the criminal complaint, and will go through each charge you're charged with. So let's say that you're charged with DUI and reckless driving. Those are misdemeanors under Nevada law. So under Chapter 174 of the NRS, basically, the judge has the responsibility to go through your charges with you and to explain on whether or not you understand the charge brought against you. The judge is not asking you if you agree with the charges. The judge is only asking you if you understand your charges. That's the goal of the arraignment. And if it's a misdemeanor charge, basically you enter a plea. You have the option to plead guilty, not guilty, or no contest. And once you enter your plea, let's say you enter not guilty, then the judge will set for a pretrial conference. A pretrial conference is where your attorney and yourself will basically try to make an agreement with the DA and see if you can have a resolution in your case. And if not, it'll get set for trial. If you're charged with the gross misdemeanor felony matter on your criminal complaint, the judge will set for two different hearings. A preliminary hearing, which is similar to a pretrial conference, where you and the DA will try to have a resolution, and you'll have a preliminary hearing set just in case your prelim doesn't go too well. So let's say you cannot come up with a resolution with the DA at your prelim, then your preliminary hearing could be set, and you'll have that hearing set for whatever day the judge may set it at. And you have a right to a preliminary hearing within 15 days. Sometimes your attorney will advise you to waive your 15-day right. You'll still have a preliminary hearing, but you can sign a waiver to not have it in 15 days, just so your attorney has more time to review your case and to basically come up with a resolution with the DA. Okay? And then after the prelim, then assuming that the DA has met their burden, which is slight or marginal evidence, basically probable cause, very, very low standard to show that you need to answer the charge, then you'll have your jury trial. And typically that's far out in the year, but that's the process of an arraignment. So remember, the judge is basically telling the defendant that you are charged with these certain crimes, and if you understand them, not if you agree. Therefore, the defendant should not make any incriminating statements, because if the defendant tries to disagree with the judge and admit to anything, guess what the DA is doing? The DA is literally grabbing their laptop and they're typing down every sentence you say, the defendant says, and they will use each and every statement against you. Therefore, the defendant should literally shut up and just say, yes, Your Honor, I understand my charges. Then the dates for the pretrial conference will be set, or if it's a felony gross misto, then the prelim and preliminary hearing will be set. Talk to the attorney. That's the best bet.